Good morning. This is Amanda DeGainer, court clerk. Can attendee Nevada Detr, please start your video. I just want to confirm that your video is working and confirm who's participating under that name.
Can you hear us?
Yes, I can hear you. Thank you.
Okay.
I have an attendee now named Nevada Detr. Is that the audio to the SAO Directors Conference Room?
Computer here so that if he needs to bring up any charts, but no one will be at that. There's no camera on that computer.
I'm sorry, can you repeat that? I didn't hear you.
It's the computer in this room.
Okay, thank you.
It does not have audio or video that I'm aware of. He used to pull up charts.
Great, thank you. I just wanted to confirm I didn't have a party in that shouldn't be. Thank you. Good morning. We'll be getting started here in just a few minutes. I'm just going to ask that all parties start their videos briefly to make sure everybody is ready to go. Thank you, Mr. Guanasso. Thank you. Thank you. Okay, it appears as if we have all of the parties in. If you're expecting anybody else to appear, please let me know. We'll be getting started here in just about 4 minutes. Good morning again. The court is joining the hearing now.
All right, good morning, everyone. I'm Judge Breslow, presiding Judge Department 8 of Nevada 2nd Judicial District Court. We're on the record in case number civil 20-00755, the case entitled Amethyst Payne and others versus State of Nevada, Detr, as we've been calling it. We are proceeding today, as we have with prior hearings in this matter, using the Zoom webinar platform. We are allowed to have hearings this way through simultaneous audiovisual means because of the pandemic, and as allowed by Nevada Supreme Court Rule Subpart 9 and various administrative orders of the 2nd Judicial District Court and the Nevada Supreme Court. Starting with counsel for plaintiff, would you please identify yourself for the record, as well as what county and state you're calling in from? Ms. Jones.
Good morning, Your Honor. My name is Leah Jones, and I'm calling from Washoe County, Nevada.
Thank you very much. Mr. Thierman.
Yes, Mark Thierman, representing plaintiffs also from Washoe County, Nevada.
Thank you very much. Defense counsel, starting with Mr. Ott.
Thank you, Your Honor. Greg Ott from Carson City, Nevada, joined by Administrator Gott, General Counsel Troy Jordan, and Chief Economist Schmidt.
Very good. And Mr. Whitney.
Good morning, Your Honor. Good morning, everyone. Robert Whitney from Clark County, Nevada. Thank you.
Thank you very much. Would the special master please identify himself?
Yes, good morning, Your Honor. Jason Guanasso, reporting from Washoe County, Nevada in my office. Thank you.
Thank you very much. The court's clerk, Ms. DeGaynor.
Your Honor, Amanda DeGaynor, Court Clerk, Washoe County, Nevada.
Thank you very much. And the certified shorthand reporter.
Isolde Zinn, Washoe County, Nevada.
Thank you very much. If you see a unfamiliar name, folks, identify that's the court's new law clerk, a recent proud graduate of UNLV Boyd School of Law. All right, well, let's get right to it. Much to go over. We initially set this hearing to review the court's continuing or lack of continuing jurisdiction to preside over this case while the appeals are pending. The general rule, as we all are familiar with, is that once a party who is unhappy with the court's decision on important matters in a case takes an appeal to a higher court, as is what has occurred by both the plaintiff and the state of Nevada, cross-appealing this court's decision on the writ of mandate. Usually the trial court is divested of jurisdiction and may not further proceed other than on ancillary issues for which the court retains jurisdiction. So the status here is plaintiffs have appealed, as the court reads it, the decision of the court not to fully grant the request for writ of mandate. In other words, as the court understands it, the plaintiff is aggrieved and seeks appellate review because this court did not go far enough with its order directing the state to do certain things. The state, in response, counter appealed. And whereas plaintiff argued to the Nevada Supreme Court that this court failed to go far enough with its writ of mandate, the state of Nevada counter appealed and said this court went too far and ought not to have issued the writ of mandate in the first place. So there are competing appeals. The question the court asked for supplemental briefing on was whether this court retains jurisdiction to move forward, notwithstanding the competing appeals. The court has received and reviewed the respective briefs from each side on that issue. So we will discuss that further shortly. Also, the question that we were to take up today, if the court determines it has continuing jurisdiction, the court directed the special master to proceed with further investigation, analysis, and filing of a second report, which he has now done. As with the first report, it was obviously the product of a lot of hard work by many people. It contained detailed factual analysis, as well as consideration of processes and approaches being utilized both to comply with the court's order and also to address continuing concerns the court had with issues that were not yet the subject of a writ of mandate, but were still in play. So shortly, I will ask Mr. Guanasso to have a brief overview and a PowerPoint highlighting the issues in the report that bear on the court's determination. In addition, we now have a request by plaintiff for this court if it is not inclined to expand the scope of the writ of mandate further, to certify as final its prior decision, granting in part and denying in part the writ of mandate application. Thus, as the court understands it, placing the plaintiff in a better procedural posture to seek appellate review. The state has responded to that request and has taken a position that the court ought not certify its prior ruling as final. On the other hand, the court did review the state of Nevada's recent filing in the Nevada Supreme Court, and it looked a little bit incongruent. In other words, it seemed to the court that the state would not object to some level of appellate review or consideration. So I'm not putting words in the state's mouth. I want to hear from the state what its position is, because this court was a bit confused. I note as well that we have now received a statement for professional services from the special master, identifying the professional charge, legal fees, and associated administrative expense. And I want to discuss the process for that being paid. Those are the issues that the court has framed in advance of this hearing. There may be others that the court's missing, but before I turn it over to Special Master Guanasso, let me start with Mr. Thierman. Did you expect that we would discuss this morning the issues that the court has just identified? Are any of them new to you, or is there anything the court, in your estimation, may have overlooked?
No, well, there is also we filed a notice of contempt. I didn't think the court was going to get to it today. I would suggest, however, that in light of the report, one would like to see the number of exhibits attached showing that they haven't followed the order at all. We might want to go through that, or we might want to consider, rather than the conclusion of the report, the actual content of the report.
Well, it's interesting you make that distinction, because reading the report, the court did have some questions and concerns. But when you get to the conclusion, you saw the special master's professional opinion that there was substantial compliance with the court order. So, you know, there's a story to be told there and an analysis to be had. But with respect to the plaintiff seeking this court to hold a hearing or otherwise find the state of Nevada in contempt for failing to abide by and follow this court's prior order, we can talk about setting up a briefing schedule and having a hearing date, but we will not be getting to the actual merits of such a motion today. And let me just mention this, Mr. Thierman. Your office appears to be, and often for good reason, often probably less so, in the habit of filing things and then simultaneously filing requests for submission, which that does certainly trigger a heightened level of review by the court or immediacy, but it often is too early. It's premature, because I need an opportunity for briefing schedule, a hearing, and notice. But I am aware that was filed last night or this morning, a second motion asking this court to hold the state of Nevada in contempt. All right, having said that, anything else you'd like to make a preliminary comment on with respect to how this will go this morning?
No, Your Honor. I mean, no, I mean, you've pretty much said what I expected to happen.
All right, very good. Thank you. Mr. Ott, same question. Did I bring up issues that you were not anticipating we would discuss? Did I miss something that you thought we would handle? Realizing, of course, that your position is that Judge Breslow, you don't have jurisdiction to move forward anyway. So we can talk about anything you want, but you don't have the ability to actually do anything other than possibly determine how and when Mr. Guanasso is going to be paid. But having said that, what's your view?
Thank you, Your Honor. The only thing that the court mentioned in its overview that was not in its scheduling order issued previously was the bill for services issued by the special master. I expect that the court would take up something with regard to briefing on that or some sort of scheduling. So I don't have an issue. Would say that with regard to the contempt, our understanding was the previous motion had been filed. The court had held that in abeyance and in effect set this status conference and assigned the special master to look into issues so that we could avoid that if necessary. So I would assume that the second motion for contempt would be treated the same way, and maybe the court will set something after today, but I didn't think there was a need for any response based on the court's prior rulings on.
All right. Well, no, that's generally consistent. I mean, what I'm taking from Mr. Thurman is, Judge, now that we know more than we did before, and now there's been additional time that's gone by, and now that we've had a chance to confer further with the special master and review his report, including any possible drafts, here is our, new and improved motion for contempt, containing additional reasons. But in terms of making a decision on that, no. In terms of giving the state an opportunity to respond in writing, have an actual set hearing on a order to show cause why the state should not be held in contempt, including from both sides briefing on what the available remedies would be for this court in the event the court found contemptuous behavior. That would all be part of the briefing. But that doesn't mean it would be held out in October. It just means it wouldn't be today. But again, that presumes this court has jurisdiction to hear matters like that at this time. With respect to the master's billing, let's start there first, and then I will give Mr. Guanasso an opportunity to present an overview of his most recent report. But let's just review procedure with respect to the payment of that bill or an opportunity to be heard on that. Recalling that rule, multiple screens going simultaneously here. All right. Rule 53, subpart G. Generally identifies the manner in which the court may allocate the expenses of the special master. Now, I've repeatedly stated that, absent a decision to the contrary for good cause shown, it would be the responsibility of both sides. Mr. Thurman has taken a bit of the offensive there and already filed affidavits of financial hardship on behalf of the named plaintiffs in anticipation, not just of this type of a dialogue, but any other issue requiring payment of fees or costs by the plaintiffs. So, Mr. Rod, it's not going to be a surprise when the plaintiffs ask this court to allocate to the state 100% of the responsibility to pay for the special master's fees and costs. But no determination will be made on that point today. What I'll do is allow the state 10 days from today to file a brief on its view on how those fees and costs should be allocated, plus those that are being incurred from the date that bill timed out through the further work of the special master. And I'll give as well from today 10 days for the plaintiff to file their view of how the court shall allocate it. And I will decide this in our next hearing, which will be about 7 to 10 days after that. Whether this court has continuing jurisdiction on other issues or not, we will have a hearing on the payment of fees and costs sometime in very early September. All right, so that's how the court plans to handle that. But certainly, if somebody has thoughts they want to put on the record as to that issue alone at this time, Mr. Rod, I'll certainly hear from you first.
Just want to clarify that the court's intent is to just have a single briefing, no oppositions or replies.
Simultaneous briefing, much like we did on the question of the jurisdiction of the court after the appeals have been filed.
Thank you, Your Honor.
You should tell me everything you need to tell me in one statement. The state knows what the plaintiff's view is going to be. the plaintiff knows what the state's view is going to be, I presume. And the court will make a decision on the record, I presume, at the hearing sometime in the first or second week of September. All right. Mr. Thierman, any thoughts on that you'd like to put on the record, or Ms. Jones?
No, I mean,
All right.
we'll address it during
All
the
right.
10 days.
All right. Well, since we're thinking of it, and once I move off of this, I may forget to come back. Let's set a date and time. Today being Thursday, and so is the first Monday in September. Is that Labor Day? Let's see. Okay, I see the 7th is Labor Day. So let's say by August 31st, Tuesday, August 31st, close of business, simultaneous briefs on your view of how the court should allocate payment for the professional services of the special master. And then let's pick a date and time for a hearing on that issue in particular, and to the extent there are other issues, if the court has continuing jurisdiction on other issues, let's set a hearing as well on those. So are parties available 9:30 on Thursday, September 10, starting with Mr. Thierman and Ms. Jones?
It's clear, Your Honor.
Thank you. Mr. Thierman?
Yes, it's clear. I just want to check one thing with my secretary.
Okay.
But I'll come back to it if it isn't. All right.
All right. Thank you, Mr. Ott. Will that work for the state?
Yes, it works for me.
All right. So we'll set this then for Thursday, September 10, 9:30 in the morning. The agenda right now solely consists of discussion with respect to payment of the special master's fees and costs. All right. Now let's move to Mr. Guanasso, if you would kindly give all parties and any attendees an overview of the work done, conclusions drawn, and recommendations set forth in the second report of the special master, which was just recently filed.
Yes, Your Honor. Thank you. Can all the parties hear me just fine? My wife said the last time I did this that it sounded like I was screaming, so I'll try not to yell at my computer as I deliver this summary. But if you can't hear me for some reason, please let me know that I need to speak up. What I'd like to do is just go ahead and share the screen here. And Your Honor, if you could allow me to do that from your end, then I can share the screen.
All right, I ask the court clerk, Mr. Gaynor, who I think is controlling the keyboard here, to go ahead and let you share screen here.
Okay, you should have access to share the screen now.
Thank you.
Nice family.
Thank you. Sorry. Well, Your Honor, to begin with, I just want to let you know that the table of contents, I submitted an errata this morning because I made some mistakes in the table of contents. I filed that. So if you and the parties wouldn't mind inserting the new table of contents so it's a correct reflection of what's in the report. I just wanted to begin there so that you understood what I filed this morning and why. I structured this report to follow along with the court's prior order. You had asked, Your Honor, that I be your eyes and ears and that I prepare a second report. that would provide an update regarding compliance with the court's writ of mandate, as well as progress being made on issues that were outlined by the court or for which there wasn't an order yet issued. So in furtherance of your direction, I worked with plaintiff's counsel, several phone calls, emails, asking for information. I worked with claimant advocates. I worked with Detr, ESD attorneys, staff, to aggregate and analyze the available information and then to put that into this report. And so the way that I'm going to talk about this report is to break your order into 3 parts. And then I have a section that'll talk about additional actions that Detr and the state of Nevada are taking. I had some observations and recommendations and conclusions, understanding that my role is only a fact finder role. You know, my observations, recommendations, or conclusions are not pertinent to your ultimate conclusions, Your Honor, but for completeness, I provided those for your review and for the party's review and for the public. So let's start with the first part of your order, having to do with payments being paid. Detr provided an overview of the payments being paid. So if you'd look at page 6 of the report, there's a total number of unpaid PUA claims, 243,963. Total unpaid PUA with another program eligibility, roughly 53,292. But with regard to the specifics of your order, and this had to do with individuals who had experienced a stop in their payment, Detr had determined that there are 30,647 claims that had experienced a stop in payment, as was described to the court previously. Of those claims, this was kind of the breakdown of what Detr had submitted, that there are 7,407 claims that had failed to file weekly claims or were disqualified for excessive earnings. There was a balance of claims that stopped for other reasons, which totaled 23,240. Detr determined that 2 of the highest numerical categories stopping payment were unlikely to meet the court order standard for clear and convincing evidence of fraud. And then Detr identified 3,500 claims that were stopped for possible fraudulent filings, but as of August 18, the new director, Director Cafferata, confirmed that those 3,500 claims have been released from fraud holds in the past 3 weeks. The plaintiff, the way I structured this, Your Honor, as you could see, is I allowed Detr to provide information as to what they did to comply with your order, but I allowed plaintiff's counsel to review those responses and provide specific rebuttal in the hope that it would help Your Honor understand the positions of the parties with regard to compliance with your orders. And so throughout the report, you'll see Detr's representations with regard to compliance, and then the plaintiff's response thereto. Again, I hope it's helpful for you to draw into relief the disagreement over whether or not your prior order is being complied with or not.
Well,
So,
let me just comment. I do like the approach you took of asking the state for its position and then giving the plaintiff the opportunity to challenge that, which plaintiff often and repeatedly did. But the way that you set that up was informative to the court.
thank you, Your Honor. And so with regard to this first part of the order, the plaintiff maintains that Detr is still in contempt of the court's order requiring payment by July 28th of 2020. You know, the plaintiff doesn't, or said that, Detr doesn't have the discretion as to whether or not to comply with your orders or not comply with your orders. Once you issue an order, they're required to comply with it. And plaintiff's position, as you can see in their rebuttal, was that there was an admission that they don't believe, that Detr doesn't believe that first appeals will be heard until, the second half of September. Detr, according to plaintiffs, also admits that there have been 53,292 claims that have other program eligibility. Just going back to the numbers, the overview numbers, it should be noted, Your Honor, that of the total unpaid claims, Detr has represented that 186,826 have fraud flags associated with them. So that means that the universe of claims that don't have a fraud flag associated with them, if my math is correct, and I don't claim to be a mathematician, but just doing the simple arithmetic, I think 57,137 claims are really claims that don't have fraud issues, but may have some other issue, which I'll highlight a little bit later in this overview. But returning to the report, before I move on to the second part of your order, Your Honor, are there any questions?
Here's the answer. I don't want to knock you off stride. I want you to get through this. I'm going to ask you to go back and explain a few things in the report. And then I'm going to allow counsel to speak on their view of the report. And then we'll go from there. So short answer, please move forward.
Thank you. The second part of the report, or second part of the your order, Your Honor, starting at page 13 of my report, really had to do with covered individuals and whether they were being paid or not. And there was an issue about how coverage would be defined, and you provided clarity as to how you wanted that to be defined. And I think the Department of Labor in UIPL 16-2 changed to clarified some of the eligibility definitions consistent with your order. And so with that in mind, Detr stated that there are no claims that are currently unpaid pursuant to the claims addressed in your order and under this UPL. Detr represents to the court that payments have been denied when their income exceeds the weekly benefit amount as required by DOL guidance. In response to this, the plaintiffs do not know who or what level or what was asked of Detr. I just represent to you, Your Honor, and to the parties that, I was very straightforward, and I just asked Detr, with respect to each part of your order, to submit everything they had that would demonstrate compliance with each part of your order. And I went back to the last hearing where they had submitted a supplement. I started there and crafted that into the report, and then asked Detr, is there any update that you'd like to give with respect to how you've complied with this part of the order? And they provided updates for me. And so what you see in this report is a reflection of that process. So I hope that at least clarifies to plaintiffs who or what level or what was asked of Detr. Because, again, I didn't want to make this overcomplicated. I just wanted to be very direct per the court's order, per the court's direction to monitor compliance with your order. Plaintiffs last night, you'll see, submitted supplemental documentation with emails that they've collected, and they've categorized that. That was not a part of my report. I did invite plaintiffs to collaborate right immediately after the last hearing and to provide whatever they thought was pertinent to include in the report. And they encouraged me to work with the folks at the PUA Facebook group, because a lot of the information that they have gathered has, in some way, been shared with them through that group, and or they've received emails from individuals who are members of that group. And so I would expect that a lot of their emails that they've received are similar to a lot of the emails that I've received and analyzed as a part of this report. Moving on to part 3 of your order, Your Honor, you wanted us to examine the progress made on other issues and determine if, and you want to determine later if other further relief is necessary. You wanted to specifically know the status of resolving the UI PUA loop or the dichotomy that existed. And if you recall from the last hearing, Detr had identified 4 possible ways to expedite the processing of these individuals. The first means having pay people before determining eligibility. They explained, and this was outlined in my previous report, that that's not a legal option, and the court agreed that option was specifically prohibited by the Department of Labor and wouldn't be a remedy that this court would consider in light of the current state of the law as articulated by the Department of Labor.
Well, that really, I mean, I think we all know that never really was a serious consideration by the court. Everyone's aware there has to be at least preliminary determination of eligibility before benefits can be paid, but I'm glad you noted it. What was the next issue?
The next approach to solving this particular problem was to expedite the determination of eligibility by assigning more resources to existing process. The third approach was to undertake efforts to reach an eligibility determination earlier in the process. And then number 4 was to improve processes to accelerate determinations for individuals whose PUA UI eligibility is initially unclear and may have to undergo multiple eligibility determinations. And so I outlined in my report, starting on page 15, under each of those considerations, what Detr was specifically doing to, 1, expedite the determinations of eligibility, 2, undertake efforts to reach an eligibility determination earlier in the process, and 3, to improve their processes. And they've taken significant steps under each of those proposed ways to accelerate resolving those issues. They've taken significant steps under each of those approaches, as you can see in the report. In order to kind of understand what is occurring from the claimant's perspective, and then to have Detr make sense of what is being complained about by both the plaintiffs that are part of this action and those who would be impacted by the court's orders regarding the plaintiff's action. I spent some time with Detr. If you recall, at the last hearing, Detr had taken some preliminary information that was a part of Appendix 1 and 2 of my last report, and did an initial analysis and came to some conclusions about that small sample size. And so, but in speaking with them, they'd said that the way that I had set up that database and the information was unwieldy for them and took a lot of time to work through. And so I worked with them on developing an Excel template that would be efficient for them to review and analyze. And once they provided that Excel template, then I was able to take 4,000 emails and all of the documents and the binders that were prepared for the last report, put those into a database and present them to the to Detr for review and analysis. Your Honor, I did not submit the emails themselves or provide the Excel spreadsheets because there was really sensitive information that was being submitted, and I didn't want to make that a part of the public record unless you directed. But if you or the parties need those Excel sheets or want to review those Excel sheets, they can be made available at your direction, Your Honor. But having said that, Detr took the information that was provided, and the analysis that follows is the results of that of their analysis of this aggregated information. And what you'll find is that about 53% of the claims in that sample size were paid. And then you'll find that 21% of the claims were flagged for potential UI eligibility. And then you'll find that there are other categories that that the Detr had identified as pending issues preventing payment. Again, the large one that I wanted to bring to your attention, Your Honor, was this one here, the potential UI eligibility. This goes into some of the discussion we're going to have about the that we've been having about the UI PUA loop and some of the issues of getting people paid that are caught up in that loop. But in talking with counsel for Detr, we were both, I think, encouraged by how the data that's reflected in this and the analysis that resulted from the data that was provided is really consistent with the smaller sample size, the findings from the smaller sample size that was presented to you at the last hearing. And we're encouraged that this breakdown is consistent with a lot of the other reporting that Detr has provided regarding claims that have been paid, claims that have not been paid, and the reasons why. Of the claims that were looked at, there were some were being investigated, and classified special project. There was two-factor authentication issues that were identified, and others that are self-explanatory in the chart. And these charts are self-explanatory as well, so I won't spend a lot of time on them. In response to this information that was analyzed and reviewed by Detr, plaintiffs responded that that there were 385 claims that have a monetary eligibility claim or sufficient wages for UI eligibility, calculated about 66%. 90 have existing ineligible UI claim, but have sufficient wages to qualify for UI now, as additional wages have been reported since the ineligible UI claim was created. And then 65 have an eligible UI claim that ended, since eligibility for PUAC was established, and should therefore be PUAC eligible. One of the follow-up questions that you wanted addressed as a result of your prior order was, what steps have been made to move first filers to the front of the line? And Detr's response to that in their statement of compliance was to identify roughly 67,580 PUA claims. And as of August 18, 2020, Detr has paid 48,850 and approved that have been approved and paid. 805 additional claims have been resolved. 9 identity checks have been resolved. 582 cases were with unemployment wages that have been resolved, and a reduction in 56 cases with no weeks claimed. It's important to note that in the last 2 weeks alone, Your Honor, with regard to these first filers, $40.1 million of benefits have been released in the last 2 weeks. And then the breakdown of the months that were paid retroactively appears here as well as in the report.
But I'm aware that Speaker Buckley is making it a priority as well to see that the first filers, or those that have gone the longest with no payment, be at the front of the line. And so I'm encouraged that she recognizes the importance of that. And even though I told you I would sort of wait until you concluded to make comment, I will note that I'm encouraged by the progress, at least as to this issue.
Yeah, I think it's significant progress. Now, plaintiffs may point to the fact that there were I think if there were a number of these claims paid, but a number that haven't been paid. So in so much as we've identified claims that have been paid, I think the plaintiffs would say, but yeah, there's several claims that have not been paid to date, thousands of claims. And so what about those folks? And I think Detr's response would be, we're working through these as quickly as we can. We've made it a priority. And if you want evidence for how quickly we are working, just look at the last 2 weeks and understand that as you pointed out, Your Honor, the priority right now is to make sure that those who are first in line have their claims resolved. That means either getting them paid or making some determination with regard to whether they're eligible for payment or if they're eligible for some other benefit or not. With regard to the retroactivity issue, Detr explained that 95,000 claims for benefits were received between February 29th and May 5th, 2020. Detr reviewed those claims for this period and determined that there was not a unilateral denial of benefits. And Detr has paid 29,724 claimants for the week ending March 7th, 2020.
Well, let me make sure I understood that last sentence, because the court was concerned, as I've indicated, that people appeared to believe that they were being denied benefits if they sought a level of benefits for COVID-related loss of income for the last week of February, sliding into the first week of March, a time period before, as the court recalls, the first confirmed case of COVID-19 appeared in Nevada. And this court wanted to hear Detr's response to those professed concerns. What I just heard you say, Mr. Guanasso, is that there was no, to use your phrase, blanket denial, no directive from the top that said, we are not paying the people who seek benefits for that period of time because that predated when the pandemic started to have its effect on Nevadans. There is none. According to this report, that was never their policy, is not now their policy, and will not be their policy. They are paying it if the person otherwise qualifies and is processed along with anybody else, unless I'm misunderstanding, Mr. Guanasso.
No, you're not, Your Honor. And I think the key terminology is in looking at this relevant period, Detr's merely looking to make sure that there's a COVID-related reason for the job and wage loss.
Well, and look, that applies to everyone. but it's a little trickier, admittedly. I'm going to just use some common sense here. It's a little trickier to pull that thread through for a period of time as early as end of February. You have to, convince the reviewer, convince the state that that's a relatable claim. But my concern was that the state is not uniformly denying or blanket denying claims merely because they had a date in mind, and those that sought benefits prior to such date automatically would be denied. You've explained to the court that Detr advises you that's not the case. Now, does that mean they're doing everything else the way the court expects them, hopes them to, consistent with the law, or otherwise doesn't invoke any challenges from the plaintiff side of this lawsuit? No, it just means that you've convinced the court at this point that Detr is treating those claims like any others, reviewing them for eligibility and making a determination as best it can.
Yes, Your Honor. Thank you. And, my report is only as good as the information that I've received. And I take Detr at its word, as I do the plaintiffs and others who have provided me with information, that they're providing me with information that's true and correct based on their best knowledge and ability. And that's, I didn't do any independent review, and time would not allow, for me to be an investigator with that as a mandate. I think the court's mandate was for me to report what is happening based on what the parties are representing, and not to, try to verify each and every one. Because again, my best
100%. We don't have the luxury of the time or the resources sufficient to have you or your staff or someone else do a quality control of what they're telling you. But they're aware, both sides are aware, that the court has indicated that it's expecting cooperation from both sides with your reasonable request for information to assist in the report and to assist in having the court understand the issues better. So
yep.
It's clear to the court you've accepted the representations. Now, having said that, it's not lost on the court that the plaintiff has some concern that the information you're getting, while the person communicating it from the state might be accurate to the best of their ability or thinking, the plaintiff has indicated in their response, as the court saw, that sometimes the court's getting different numbers, or that you're getting different pieces of information on the same subject, and it's a bit incongruent. And so, that's, but I don't see in your report anywhere where you're suggesting that anyone is specifically or intentionally hiding the ball, or otherwise trying to be disruptive or non-cooperative in your job task. To the contrary, you're indicating that each side is trying to provide information to help you do your job. So that's my takeaway.
Yes, Your Honor. And I want to highlight that last point, and that is both parties, plaintiffs as well as the state, have been exceptionally generous with their time and their effort to get me information that I've asked for. And at whatever time, I'll ask for the information at 5 in the morning, 11 at night. I send emails at all hours of the day, trying to get, answers to various questions. And without exception, I get responses within an hour, and the assistance I need. The only, only when there's like a difference of opinion as to who's the best source of information, has there been, a further discussion of what's needed, and plaintiffs in that regard had pointed me to additional sources of information, with regard to their clients and some of the issues that they were having. And plaintiffs represent to me on this issue that there are still claimants who believe they're experiencing this retroactivity issue. But based on Detr's response, it appears to me that's maybe a misunderstanding of the people who are not being paid, and there may be some other reason that they've been determined ineligible, but it's not because of the time that they filed. Really,
Well, that was the court's concern.
Yeah.
I mean, are there other issues with their ability to be paid that flow throughout the rest of your analysis and report? And might those issues apply to these first filers also, or to the retroactive group of filers? Sure, but the court was concerned that there was a determination not to process these payments. That really is the essence of the court's concern on that issue.
Yes, Your Honor. Yes, exactly. So with regard, so having addressed the court's concerns, I'd like to move on to another aspect of the report that I think will help, Your Honor, with context and understanding what is happening from a user, so that is from a claimant's perspective, and how they're interacting with the state system, and really help inform the court about, you know, the many issues that have given rise to this complaint, because this is really a snapshot into the extraordinary volume of communication that plaintiff's firm has been getting, as well as this PUA Facebook group regarding issues that they're having with Detr system. And this was, you know, my way of trying to check, you know, like Detr's telling me one thing, what is happening, you know, on the ground in the real world. And admittedly,
Well, and in real time, right? Isn't that
Yeah.
another concern, that there might be a lag between what you're hearing from the state as they have matters presented to them, look into them, attempt to redress them, and then report back? There's a lag between what people in real time are experiencing. At least that was the sense the court got from reading your report.
Exactly. I couldn't have said it better myself. Exactly. There is a lag, and that's a big frustration for individuals like Amber Hansen, who's administering this PUA Facebook group, and listening to these presentations that are given and the representations of Detr from one press conference to another, is that it seems to be a 2 or 3 week lag between, you know, solving a problem and new problems that emerge. And they're, you know, from day to day, there are new problems that emerge with their system. And Detr put it to me this way: when they stood up the PUA program in May, they explained that it was as if they were trying to construct a airplane while flying at the same time. And they had no opportunity to really test the program when they released it, you know, when they stood it up. And so all of the glitches, the problems, the complaints, really, if you could go to like, you know, an original source, it would go to the launching of a program that really hasn't been stress tested for all of these issues that have been identified. And then ultimately seeing the response of claimants to the program, and then trying to adjust based on the information that they're getting. And Detr,
Hey, listen, let me interrupt. Sorry. The analogy of, you know, flying the plane while you're building it, that's been used in a couple contexts. I understand the analogy. I understand the realities of having to deal with setting up a program like this under such difficult circumstances. But Mr. Thierman and Ms. Jones are going to say, but Judge, we have 60,000 people that are flying on that plane, and we're expecting it to be safe and sound and get us to where we want to be. And, you know, or else we need a different plane or a different captain. I don't know what they're going to say, but that's the essence of it. But it's not lost on the court that Ms. Hansen, obviously putting a lot of time and effort, both to help other people and also to make the platform available as a resource, both for the state, for plaintiff's counsel, for you, for the court. That's much appreciated. And it's certainly not lost on the court that that's been a big lift for her. But I will caution all counsel in this case, and also the special master, if you're going to file something that shares screenshots of any of the Facebook posts or any other social media posts, please do the court a favor and just screen it for, you know, the random 4-letter word or the R-rated word, because I really frown upon that. I understand we had a little bit of time of the essence here. We wanted to get the sense of what people were experiencing, but do the court a favor and make sure that that we black out words like that. The other thing is, as just a reminder, and then we'll get back to the report summary, Mr. Bonasso, is careful when we file papers with the court that identify the names of people who work for Detr or work for the state of this case. I'm sure that while they're working as hard as they can and doing the best job they can, they would prefer to, you know, remain anonymous, so that if somebody indicates that they've called and talked to so-and-so and then he or she said this, let's try to black that name out, or just identify them by the first letter of their names, just to for you know, confidentiality's sake and things like that. All right. Having said that, let's move forward. So the Facebook groups have been assistance to all parties in this case. Is that fair, Mr. Bonasso?
Yes, that's right. And as you pointed out, Ms. Hanson and her team that are administering this Facebook group have been extraordinarily generous with their time and the information that they've had. And they've been willing to, I gave them kind of a structure that I needed, and they were able to respond to that in a timely fashion. And so what you will find as a result of this collaboration and the good work of Ms. Hanson is identification, and this appears at page 43 to 45 of my report.
Yeah,
this is
like
just the
30 or 40 different types of issues that people are experiencing when trying to attempt to make a claim for benefits, right?
Yes, and having these identified, and then what you'll see in the rest of Ms. Hanson's report is specific examples under each of these categories of what they mean when they establish. So, you know, first-time filers we're all familiar with, but there are other issues that, you know, we haven't necessarily talked about in these proceedings, like the PUA debit card, no payments issue, right? Or cannot file for weekly claims for back pay, and paid for current weeks, and things of that nature. And so I thought that would be of assistance to the court, not only to identify the issues, but then to provide specific examples with regard to each of those issues. And not only would that be of assistance to the court, but that would be assistance to both the state as they're trying to fix the system and make it more efficient and make it more responsive, and make sure that it's delivering benefits to those eligible individuals who file claims, as well as to plaintiffs' counsel, so that they could better articulate, you know, the issues that their clients are having, you know, with the system, and proposed remedy to the court. And so I won't go through the details of Ms. Hanson's report, which I think is excellent and speaks for itself. I lay it all out for you in the pages that follow. But again, you know, for the record and for the court, I just want to say how much I appreciate this group of volunteers being willing to share this information, because I think it provides a cogent snapshot as to, you know, how claimants are interfacing with the system. And I think it should illustrate something important, Your Honor, and that is this. Oftentimes, Detr and the people that are applying for benefits are speaking a different language. And so in so much as this report can help translate, you know, between, you know, Detr's understanding of their program processes and solutions to various problems, I hope that I can translate that to, you know, what the claimants are experiencing and vice versa. And I think, you know, that's what Ms. Hanson was trying to do, as well as be a translator, so that we could understand, so that the two parties can understand each other and begin really working on solutions that will solve the actual problems that people are having in the system.
Okay, hold on for just 1 second. Ms. DeGaynor, can you hear the court?
Yes, Your Honor, I can.
Would you please, all right, would you please email the court's judicial assistant and ask her to move the hearing that I have tentatively set this morning at 11:30 on the preliminary injunction matter that the court received yesterday to 1:30 this afternoon, and see if the parties are available to participate at 1:30. And then after you hear back from the court's judicial assistant, even if we're in this hearing, please let the court know what the status of that is. Thank you. All right, Mr. Guanasso.
Thank
Please
you,
proceed.
Honor. I'll go ahead and wrap up now. Again, I'd encourage those, the parties and the court. I know the court's already looked at what Ms. Hanson has provided to take a look at that, because for each of these issue areas, there are cogent examples that are worth consideration. For how to make sure that the remaining eligible individuals who have not been paid to date get paid. That being said, I wanted to give you some context before I move on to my observations and recommendations in conclusion. This Facebook group represents 15,358 active members. So it's not just a small closet community of 200 people. I think it's a good representative sample of a large population of people in the state who have questions about the system, who have problems, who are trying to get issues resolved. And I think it's notable that they've had to resort to this outlet to be heard, because the current system, the state system, has been so overwhelmed that I don't think that the individuals who have issues feel like their complaints and their issues are being heard. And so this provides a platform for that to happen. And I'll just leave it there for the time being and move into my observations and recommendations. And first, I think with the issue with the UI PUA loop, as I point out, there was a policy choice made to have a UI system and a separate PUA system. And if a person didn't qualify for UI, to send them to PUA, and if they didn't qualify for PUA, but all of a sudden had some eligibility for UI, to send them back to UI. And I think Speaker Buckley has identified this as an issue as well, that having a way to manage these claims from start to finish, and to make sure that there are no interruptions. So if you have a person, like I had an individual who is a pianist who performs in the casinos down in Las Vegas, he's an independent contractor, works based on the shows that he has, and was receiving benefits as a result under PUA. But between the time that he started receiving PUA and the time the second quarter began in July, he picked up some work teaching piano lessons, and he was making roughly like $62 a week. And as a result, he accrued UI eligibility. So that disqualified him from PUA and required him to go back to UI. And it seemed like that's a scenario. The reason why I give that fact pattern, because that's a fact pattern that repeats itself quite a bit as people are trying to make ends meet. And the disqualification ultimately results in a loss of income, and then requires not only a reapplication to UI, but then an exhaustion of whatever's in UI, which is usually pretty de minimis, and then a reapplication to PUA for additional benefits. And that process can take weeks, and indeed sometimes, with some of the examples, months. So that's an issue that I think, Your Honor, when you raise the issue of the UI PUA loop, it's something for you and the parties to maybe discuss, and certainly something for Detr to look at. With regard to,
Well, let me just hit the pause button on that issue. I just want to remind everyone again on this hearing or observing this hearing, what the court's role is. The court's role is to determine whether the state failed to do something which the law requires it to do, or is doing something which the law otherwise would prevent it from doing. And, you know, it's more nuanced than that. There are criteria, there's a standard that this court must apply in making that determination. But drilled down to its core, that's what it is. This court has already ruled that on some of the issues, the court found the state's response lacking. That's why the court granted in part the request of the plaintiffs for a writ of mandate, a very unusual order from one branch of government to another, directing it to do something. And this court held in abeyance, going further with said writ to see if progress was being made and to see if in good faith the state was attempting to meet its obligations required of it under the law. What you just indicated on the subject of the two separate systems is a well-known impediment to more prompt payment of benefits. It's a reality of the system that existed and the need, as the court understands, to quickly stand up the PUA system once those benefits became available. So system-wide changes to make that process simpler, to integrate them, to streamline it, those might be a great idea, might be on the table, people might be efforting that as we speak. But the court, from the court's perspective now is, does that make more likely or more necessary or more justifiable a further writ of mandate, or does it not? Or as Mr. Thierman will certainly argue shortly, that's great that that's happening or likely to happen, those changes to integrate, but people need their money now. And so, Judge, if you find that the progress is out there but not tangible, is prospective but not current, is not in the reasonably near future, if not immediacy, you should expand your mandate order and get people paid and let the state work out its integrated system at a later time. So I just want to explain that to people. I mean, it's not lost on the court that efforts are being made to address these types of systemic issues, but for purposes of this court's analysis on whether the writ of mandate has been complied with and whether the court should expand it, that may or may not be informative. But I'm glad you brought it up. I'm glad to know things are moving forward. And yes, I'm aware as well that the strike force that the governor appointed has made that a priority to look into. All right. Mr. Guanasso, I'll try very hard not to interrupt you again, although I won't promise that. Go ahead.
Thank you, Your Honor. This report certainly is for your benefit. So all your interruptions, questions, comments are welcome, and I'm sure appreciated by the parties and those listening. So the next recommendation is that Speaker Buckley, include a person like Ms. Hansen and the PUA Facebook group of administrators in the work of her strike force. That there's a lot of information that claimants have as to the system that could be of help. I think as Director Cafrata and Speaker Buckley work to resolve the backlog, work out the bottlenecks in the unemployment benefit delivery system, and then, turn their attention to systemic changes, having a claimant advocate as well as the perspective of claimants who have to navigate Nevada's system would provide the strike force and Detr with valuable insights and perspectives that I think will make the system a little bit more user-friendly. And I recognize this is really running up against the edges of what the court could or would order, but having done the report and seen and included Ms. Hansen in this process, I thought I would note that not solely for the court's attention, but also for defendant state of Nevada's attention and the people that they have, focused on the same issues that the court is focused on. With regard to my third recommendation, Your Honor, I just want to reiterate the concern that I raised in the first report regarding due process rights of claimants who have had their claims denied. There have been roughly 70,000 claim denials, and of those claim denials, there have been 7,787 appeals. And the first appeal hasn't been, I don't know that it's been scheduled yet, or if it has, the tentative scheduling is to begin to hear these appeals on September 15th. And so I lay out some of the details of my concern and why that may be an issue for you as you consider what further action the court may take. But having denied so many claims and to have such a large number of individuals who are now in the queue waiting for their appeals to be heard, waiting another month, could be, or more than likely will be, of great harm to those individuals who have already been waiting, several months, for a determination to be made and to ultimately show that they are eligible for benefits. Finally, Alorica remains a problem, but as I noted in my report, Speaker Buckley and Director Cafferata recognize that as a problem as well, and they're looking at either getting Alorica to the tools they need to be better at the work that they've been contracted to do, or are looking for other means to communicate with claimants and help them resolve the problems that they're having with the system. For my conclusions, for what they're worth, I'm not a decision maker. Your Honor didn't delegate authority for me to make decisions, and so I don't want to communicate to you or the parties or the public that I have any more authority than to gather facts and present them to the court for the court's benefit. But in so much as my conclusions are pertinent to the court's considerations, it appeared to me, based on all the information that was provided, that Detr is substantially complying with the court's writ of mandate and is making progress. Substantially complying does not mean total compliance. It just means that there has been substantial efforts to comply with each of the elements of the court's order. Plaintiffs certainly disagree and have raised several concerns about about Detr's compliance. Specifically, they're concerned about the people who have not been paid to date, and they want to know when these people are going to get paid. They want and how Detr's going to go about doing that. Approximately 1/5 of the pool claims, according to plaintiffs, were denied coverage because of other program eligibility. So, and I think plaintiffs, and I don't want to speak for plaintiffs, but based on what they represented to me, those should be individuals, if they're eligible for anything, they should be getting paid and paid immediately. The backlog and unpaid claims, that being said, Your Honor, the backlog and unpaid claims has been substantially reduced, particularly over the last 3 weeks. And a lot of that is as a result of the focused effort, the significant resources being dedicated to this issue by the state of Nevada to resolve the problems that Nevadans are having with our unemployment delivery system. So that concludes my presentation and overview of the report that's been submitted to you, and I'm certainly happy to answer any questions you or the parties may have as you direct.
Thank you. Excellent presentation, and again, excellent work on marshaling all the information and summarizing it in a way that the court can understand and make use of. Here's what we're going to do. The court needs to take about 5 to 7 minutes to address a few other matters. We're going to go off the record and be in recess for that time. When we come back, I'll hear from plaintiff counsel in response, briefly to what the special master just reported. Then I'll hear from the state. Again, I don't want to turn today into a order to show cause why or why not the state should be held in contempt. I want to get your sense of your response to the to the master's report and findings. But then I want to move to jurisdictional issues and see where that takes us, because we could spend a lot of time on this report and what it means, whether this court should expand, deny, or leave intact with no change its prior writ of mandate. But at the end of the day, this court needs to be assured that it has the right to continue overseeing this case in the current posture.
Your Honor,
So,
before we take our break, I want to mention just two things, and it's not substantive. So
go ahead, because I've got a few fires I need to put out. Go ahead.
I don't know if the entire report has been uploaded to the court's docket, only the first 75 pages. I think we've got the entire report, but I'm not sure it's all been uploaded to the court's docket. I think it's only the first 75 pages, unless there's been a supplemental.
So if you're talking about Mr. Ganasso's report?
Yes, yeah. So
Well,
if I'm wrong, I'm wrong, and if I'm right, he can go correct it.
All right. Well, we can ask
break.
the court clerk to check that and report back here after the break. But I reviewed what I consider to be.
I know. I can tell from what you said, you had seen the whole thing, but.
Okay. And what you said, you had two things. What was the other?
Yeah,
thing?
the other thing is if you would upload or share his slides, I appreciate it.
So the slides will be separately filed as well after the hearing is over. All right. We'll be in recess until approximately 5 minutes before 11, and we'll proceed at that time. Thank you, everyone.
Thank you, Ron.
All right, let's go back on the record. Mr. Thierman, Ms. Jones? Mr. Thierman, can you go back on mic, please? Ms. Jones? All right, I'm going to turn off the video just for a moment. Oh, here we go. Ms. Jones, welcome back.
Welcome back. Mr. Thurman's rushing to his computer. One moment, please.
Okay, sure.
Apologize.
That's all right. Okay, we'll go back on the record. So I'm going to first hear from Mr. Thierman and then from the state, presumably from Mr. Ott, to make any comments, observations, or responses to what you just heard from the special master or any of the court's questions or comments related thereto. But I just want to remind both sides here. You know, it's not lost on the court that the plaintiff has filed a renewed motion or a second motion seeking an order of this court holding the state in contempt for not fully following the writ of mandate. So, you know, this hearing in part was designed to inform each side about how, what the efforts were of the state to comply and what efforts were made on the issues that had not yet been ordered as part of the court's writ. And then to see if an order to show cause hearing might be needed. Now, the plaintiff has already apparently made that decision. They didn't wait for this hearing or this report and the summary. They decided yesterday and this morning to advance that. So, you know, I'm aware of that, Mr. Thierman, that the plaintiffs still have serious concerns with full compliance on the areas that the court has ordered, as well as concern that the court should expand its writ order to encompass more buckets of people who have not yet been paid. So you can confirm that in a moment and also make any other observations you want. But I do not want to turn the rest of this hearing into all the reasons why this court should hold the state in contempt. That will be, if ever, at a later hearing after we notice it, and each side has a right to be heard in writing, and then at the hearing. And that's only if the court decides that it has the jurisdiction to even proceed with that. All right, that having been said, what comments or observations would you like to make on behalf of the plaintiffs with what you just heard?
I think I'll let Ms. Jones talk first, but I will say that the criteria for contempt is very different from the criteria that you asked us to address today, which is how well are they doing and is there a need for further relief? And that criteria, I think the facts may overlap, but the standards are different. So let me turn it over.
Well, and in response to that, just remember this, you know, the court's prior order of mandate left open the possibility that this court would expand it.
That's right.
You know, based on further developments, and the developments are being are coming fast and furious. And depending on your viewpoint, they're heading in a good direction, a positive direction, an earnest direction, or they're not. They're not moving fast enough, grabbing enough people, or addressing some of the more serious issues that have arisen in the way the state administers the benefit program. So, but yes, whether somebody is in violation of writ of mandate and can be held in contempt, that's a different standard. Okay, Ms. Jones.
Thank you, Your Honor. We just wanted to point out some glaring defects or misrepresentations from Detr as described in Mr. Guanasso's report. The first thing I want to talk about is that the court's order stated specifically that when looking at a claim, that Detr had to consider time prior to Governor Sisolak's order on the shutdown. Detr says that there were no mass denials regarding that date issue, and that if there were, that's not happening anymore. However, I have plaintiffs received multiple tens of hundreds of representations from claimants. One, Michelle L., dated 8/7/20, that says, you are being denied. You are not eligible for PUA for the dates noted. The state of Nevada did not have any job closures or shutdowns prior to 3/6/20, and the stay-at-home declaration was issued on 3/17/20. This denial was dated 8/7. So when Detr says that there wasn't a mass denial for that reason, or people aren't getting denied for that reason, to this day, people are still getting denied for that reason. The second thing that was specific to the order is people that have not received eligibility, or they wouldn't be paid immediately if if Detr could provide clear and convincing evidence of fraud. In Mr. Guanasso's report, Detr states that some 30,000 people were unlikely to meet the fraud standard. It's not an unlikely standard, it's a clear and convincing standard. And the issue with that fraud issue is that we don't know why they have been tagged as fraud. It might be something simple as an IP address. It might be something as simple as failure to do the two-process identification. People are losing their phones. People are losing their homes. People can't afford their internet connections anymore, so it's impossible for them to do the two-step identification. There's a myriad of reasons why those people might be thrown into the fraud category that are very small. Mr. Thurman has some more suggestions about the fraud issue. The other one issue that we did want to address is the PUI UI eligibility loop. We're not saying that people that aren't eligible should just get paid. Plaintiff's position has always been, if you receive an eligibility determination under either UI or PUA, you should get paid. It's not claimant's problems that Detr has an antiquated accounting system. If you get a determination that you are eligible for UI, get paid UI. If you get a determination that says you are eligible for PUA, get paid PUA. It's one or the other. If they're eligible under both for portion, then they should get paid. It doesn't make any sense whatsoever to plaintiffs or to all the claimants out there to get an eligibility determination under one and not get paid. That might be leading to part of the fraud thing too, which I'll let Mr. Thurman talk about now.
Well, thank you. And before I turn to him, I just want to observe, Ms. Jones, you know, I hear you. The frustration you expressed are genuine, and they're certainly, again, not lost on this court. This is ground we have previously traveled. The PUA, UI, whirlpool, the the issues with being directed from one program to the other, even if the other has just something modest. The new quarter began. The court understands that. The question, though, again, I just want to remind everybody, is the state following the court's writ of mandate? Yes or no? And should the court expand its prior writ of mandate because with the benefit of further time and effort and approach and analysis, the state has been unable or unwilling to fulfill its lawfully required obligation to administer this program? Those really are the questions the court wanted to have a direction on today, as well as whether this court should even be deciding those two questions right now. The fact now, you did bring up a point I was not aware of, and that's apparently as recently as 2 weeks ago, somebody got a letter denying benefits or an email denying benefits under the stated reason that the period they sought benefits for was before the governor's declaration. Now, if that's more than a mere one-off, that would be of concern to the court, because that's, inconsistent with what I'm hearing and inconsistent with progress that I understood was being made. Now, you use the term misrepresentations or falsehoods. I forget the words. I'm going to assume that nobody on the other side of the caption here would knowingly or willfully do that. They might be misinformed or misunderstood or have data that's there's a lag time. But I'm not assigning to anybody here intentionally providing information to the court or to the special master that they know to be inaccurate or untruthful. So those are some comments. Mr. Thierman, what about the fraud level? It's of concern to the court that that people that I ordered to be paid, unless one of these categories apply to them, where payments had started. And I want to remind everyone, it's for those that had payments start and then stop. It's not those people. I'm not in the bucket yet of people who have never had payments begin in the first place. It's payments begun and then be stopped. Then I have the, you can't do that, state, unless one of the following 3 or 4 things apply.
Wow.
So, Mr. Thierman, that's it's of concern to the court that there seem to be many people still unaccounted for in that regard. What are your thoughts?
Well, my thoughts is that you got to be careful when you're given statistics. And in this case, I don't ascribe a purposeful intent or maybe to mislead, but we are never given the denominator when we're asked to find a percentage. And you can't do a percentage without the denominator. What do I mean by that? We know that there were 50,000 people or something like that that stopped payments, 40,000. They say 26,000 don't count. Okay. They paid 3,000 of them. It's 10% compliance level. 10% compliance. That's 90% non-compliance. Percentages. It's not a one-off. Hundreds and hundreds and hundreds of people are not being paid as Your Honor directed. And our statistical sample is smaller than the special masters. But it isn't that hard to go in and say who had a payment stopped and why wasn't it continued. And it's happening daily, past your order date all the time. They just don't think that you mean what you say, or they don't understand when you say something you're supposed to do what you said and then come back to you and question it. Do I have to do this or whatever? That's not the way the system, they're not following the system. And maybe because Detr is not a person, okay? It doesn't bleed like a person. It doesn't have children it has to feed like the claimants. It doesn't have to make a car payment. It's not a person. It's an institution or organization. So when Your Honor is considering the merits, think also about who we're talking about. We're talking about Detr and ordering an organization to do something And we're also on the other side, we're talking about real people who have to pay their bills, who have to support their children, who have to buy medicines, who have to sleep somewhere other than in their cars, which are being repossessed anyway. So yes, Detr's not a person. So you can't say, Detr has this evil intent, because you can't find the intent. It's all throughout. It's an organization. But we know that good people do bad things, or bad results come from organizations. And it happens over and over again. And I don't know what the misdirection is or what's going on. And not only that, with all due respect to Mr. Ganasso, I don't really care. That's not my job. I don't know if it's the court's job. It's my job to get these people paid, which the court acknowledges. And I think it's the court's job to make sure that they're following the law and not to re-engineer their systems. And there's a quick way to do it. And I've suggested it over and over again, and I keep getting criticized for and extrapolated that, I'm saying pay people who aren't approved. If Detr says you're approved, that's it. There's no conditional approval. Java doesn't allow conditional approval, or else you don't have approval at all. And Java says you got to make a decision quickly. And you can't say, well, we're going to stop your PUA because there's a possibility of UI eligibility. We don't use the word possibility in our letters. We say you are eligible. And then not give them UI, because you just said it. It's an estoppel. And yes, Detr can change its mind all day long. Look at page 31 of the report. They go from 230,000 to 91,000 claims. That's a pretty dramatic mistake, okay? Oh, we didn't mean it. Well, I'm sorry, you got to take people at face value. You have to take an organization, especially a government organization, on what they write. And if they say you're eligible until you have a due process hearing and say it otherwise. But let me get specifically, okay? The other thing about the fraud is they said 3,500 people don't have any fraud, okay? Now, I'm not a PhD in statistics, but I've done enough class actions to know that the sample size you use for any group is not an arbitrary number. It depends on the standard deviation. So you go from yes to no, no to yes, yes to no, and you keep going. As soon as you start getting narrowing of the numbers of people, that you come to a focus point, that the standard deviation is less than 3%, 5%, whatever number you pick. That is statistically significant for the entire group, no matter how big the group is. So it's not, and here we have 3,500 people and there's no fraud. That's a 0% statistical standard deviation. So that must be true, or at least mostly true for everybody else. But still they're holding up for fraud, and they still yell fraud all over the place, yet they don't have any evidence of it. And they don't even have anybody who they've actually sustained for fraud. Now, the other thing that bothers me about the report, I mean, and I know that's one of the reasons I left I wanted the whole thing on to be uploaded, because it accurately quotes our saying, which we did over and over again, that we start out with a universe of, let's see if I can find it in the report. It's in several places. It's in the conclusion, and it's in the, it starts out that Detr has not paid 243,963 people claims submitted by gig workers pursuant to the PUA assistance program. Okay, that's what Detr says in the newspaper or in the report. The last time they were here on July 22nd, I guess it was, it's July 7th. They came up with the number 139,107. They've had 100,000 more claims that are unpaid. They're going in the wrong direction. 1/5 of the PUA claims, 53,292, were denied coverage because of the program's eligibility, i.e. the loop. That's on July, that's now. Well, back on July 7th, it was only 45,000. We're not making progress. We're going downhill. And yet, I mean, I can't understand why we're saying we're doing such a great job. We're losing ground. And they don't tell us how many of these people should have been paid, or that the letters were a mistake. There's this allegation that somehow the Director God told people you shouldn't press the wrong button, and they pressed the wrong button, and they had a meeting and they said, okay, don't press the wrong button anymore. They're still doing it. I don't know if those wrong buttons are still being pressed, or whether those are the right buttons, because they won't tell us what percentage of those UI, PUI were mistakes. And if they were clerical mistakes, why didn't they send out a letter correcting it? They have never done that. They've never said, oh, we made a mistake, sorry. This was a clerical error. What they just said is, oh, you're eligible for this, and you're not eligible for that. And when you ask them, okay, why aren't I getting this? Well, it was a mistake. We should have told you were eligible for it. It's incredible. And if it were an individual, I would ask you for a perjury conviction. But it's not an individual, and I understand that. And people are getting statistics from other people, and they're getting numbers from other people, and they're looking at the numbers and they're forming conclusions. But it's gone wrong. The end result is wrong, and that's how you test it. I don't care about the steps. You look at the beginning, you look at the end, and if the end result doesn't make any sense, which in this case it really doesn't, statistically, mathematically, or humanity, then you got to say something's wrong. I don't care what the process is. I don't care how many good faith meetings they have or whatever they want to do. It's wrong. And you say that, okay, they paid $41.1 million. Great. Out of how much? Out of $1 billion? Because that's what we say it is, $1 billion. That's what they owe these people, $1 billion. And someone did the math at a higher back pay rate than we did, and it came up with $7 billion. So they paid $40 million. Whoop-de-doo. That is not compliance. And until we know the bottom number, the denominator, we don't know what percentage compliance there is. So talk about a data dump. This is a data dump where all the missing pieces would give you a better handle on whether or not they're complying. And I would suggest, just based on their own statistics, look, they start out by saying, oh, there are 50-something thousand people who should have gotten it. We took out 23,000 because of reasons that nobody really understands, or I don't anyway. 7,000 again came out because half of them or a third of them or some part of them, we don't know how many, may have a legitimate claim and the other part doesn't. So we got 25,000 left and we paid 3,000. That's not compliance. So I'm telling you that they have not complied. And the reason they haven't complied is maybe it's not simple enough for you to say, I want you to take a checkbook or a bank deposit, and everybody who's gotten cut off and has then not been restored in total, and who has not had a hearing, unless you have clear and convincing evidence of fraud, or they have interim wages higher than what it should be. It was higher than what the program eligibility would allow.
Or didn't file their weekly benefit request.
Well, they can't do that because the computer's shut off. They're not allowed to. Their screens are blocked. Same thing with the appeal. You know why there's 7,500 appeals on 70,000 denials? There's no appeal mechanism. You're told 11 days you've got to appeal. And 32 days later, a button goes on in a machine that you never checked because you've already been denied. And you know what? The button only works half the time. That's the appeal mechanism. That's not due process. You want to know about standing? The standing, that's an injury in fact. It's funny about the jurisdictional thing.
Let's hold off on jurisdictions for a minute. I wanted to get your sense of what you made of the master's report.
I think his factual investigation was very nice and very thorough. I don't agree with his conclusions, politely saying, and I don't think it makes any sense.
All right, let me hear from Mr. Ott, and then we're going to dig deeper into whether the court should make a final determination on the other writ of mandate requests, whether it should certify, if it can, under Rule 54B, its prior writ of mandate as final on the issues with respect to that claim, and whether this court has continuing jurisdiction to have a hearing on an order to show cause or anything else other than ancillary matters. All right, Mr. Ott, what do you what do you make of the master's report, the court's questions, and what you just heard from Ms. Jones and Mr. Thierman, please?
Thank you, Your Honor. Want to start off by addressing something that opposing counsel stated with regard to Detr not being a person. That's true. Of course, it's an entity, but it is made up of people. And there are people who go to work every day trying to get people paid, trying to get these eligibility determinations made, trying to solve the very problems that this court is focused on and the special master detailed in his report. We know that we have had a director resign because of threats. There are staff pressures. People are resigning because they can't deal with the stress. To have the tenor of opposing counsel asking for perjury charges and ascribing improper motives to these people is, I think, uncalled for. And I think it is also not helpful to getting claims processed, because as we are trying to hire people, it makes it a difficult place to recruit to. And so
Well, let me address that for anybody who's not participating directly on this call but might be watching. I've already found that the state is working extraordinarily hard under enormous challenges. I've already found and put in an order that I determined that Administrator Gah has extraordinary vision and effort. And then I've made comments to the fact that the men and women that work for the state of Nevada, particularly in the Employment Security Division and within Detr, are doing their level best to do the right thing. And so when I hear Mr. Thierman, I hear frustration, both from him and on behalf of his client. And when I hear Ms. Jones, I hear the same thing. But I do not ascribe in any way, shape, or form to the people that are working for the state to try to handle this crushing backlog of claims, an improper motive, a lack of caring, or in any other way, shape, or form, not trying to do their best for their neighbors in this state. That's not what we're here talking
I
about.
said if Detr was a person, and Detr's not a person. That's what I said.
Understood. And Mr. Thierman's trying to observe the reality of the fact that when you have a person in front of you, it's different than when you have an organization. But as you say correctly, Mr. Ott, it's an organization filled with people trying to do the right thing every day. The court certainly accepts that, notes it, and will proceed with this case with that understanding. So I appreciate you bringing that up.
thank you, Your Honor. I'll move on to the special master's report. One of the things that I thought was useful in the report was the ability for the special master, and again, thank him for his cooperation, to provide bulk data in a way that Detr could process to look at the people who had complaints to him. So these are, we know, people who had enough of an issue that took the initiative to send something to the special master to say, here's my problem. He was able to then communicate those to us, and we were able to then work on a sample size of about 2,500 people. I think it's 2,499 correct matches that we got after we sliced and diced the data. That data was consistent with what we had represented at the prior hearing, which was about, I think we said about 60% were getting paid, 20% were being held up for possible UI eligibility, and then there was another 10% that was fraud. So those numbers changed a little, but the larger sample, I think, confirmed what the smaller sample had showed at the prior hearing. One other thing I wanted to point out, because I don't think it was immediately clear from the special master's report, of those people who had UI eligibility, I think about 388 of those have gotten paid in UI. So the number of the 2,499 who have been paid is actually higher than the 51% that it shows in the report. It's just that 51% is those who have received payment in PUA. Some of those have received payment in UI. Another thing that is a theme is that the numbers keep changing. The numbers keep changing because claims keep coming in. People are still in need of unemployment. People are still applying for PUA. Claims come in every day. So there's always going to be new claims, and the numbers are always going to shift and always going to increase. I don't know a better way to say it, but there's a moving target there. And so numbers are going to continue to change for as long as this case is alive, and after this case is alive, the numbers will stop. Or
well, the takeaway, one of the takeaways for the court from Mr. Thierman and Ms. Jones' concern is that the number can get bigger, but the percentage of paid claims should get bigger as well. So if it's 50% a month ago, it should be 70% now and 90% later, and unless there's a valid reason not to. And Mr. Thierman is expressing frustration that it's not clear that that percentage is increasing, or even knows what the other number is. So, you know, it's just it's hard to want to be in control of data and information when you only have a sort of a piece of that. That's what the court took away.
Understood. Wanted to talk briefly about the Facebook page, because it was a source of significant information for Special Master Guanasso. He recommended that individuals from Detr reach out. I want to just briefly put on the record some of the dangers of dealing with unverified sources of information. We don't know who's on that page. That's not an official source of information. So recommendations that are being floated or circulated there may be from people who are well-intentioned and trying to help. They may also be from actors who are not well-intentioned, not trying to help. We just don't know because it's not an official source of information. So I will say that with respect to the communications that Detr gives people, it is always trying to point them to the shortest path to getting paid. So if they get a PUA letter indicating that they are being denied for possible UI eligibility, the shortest path to payment for that individual will be to follow the UI route rather than to appeal that PUA determination. So there's just a danger of other people forming opinions who are not experts and not employed to make these decisions.
Let me mention something, Mr. Robb, before I forget. The court's aware of the competing appeals. The court's aware that, and we'll talk shortly, the court may or may not have further jurisdiction based on those. But until and unless somebody overturns this court's writ of mandate, the court was very clear that people who were started to be paid and had the payment stop, they need to resume unless and until one of the following things happen or they fall into one of these buckets. And what we heard the plaintiff argue was it's great that 3,500 people have been, started again, but what about the other 20, 30, or 40,000? Are you saying, this is rhetorically, but plaintiff says, are you saying, state, that you have clear and convincing evidence of fraud, or they ought not to have been paid because they're now making more money than would allow them to be eligible, or have they failed to file weekly benefit requests? Or have they had their appeal heard, which we know that hasn't happened yet, even though it's in the reasonably near future. So at some point in time, if this court is concerned that those payments have not resumed in full for those groups of people, then there's going to be a reckoning. And that reckoning will be after a hearing where the state is able to come in and convince the court that is complied with the court's order. Not mostly complied, not significantly complied, but completely complied, other than for things out of its control. That's a bit of concern to the court at this point, but we'll see where the chips land on that down the road. Anyway, that's an observation I wanted to bring to the state's attention.
Thank you, Your Honor. Just a few more things. Wanted to address the comments that opposing counsel read into the record about someone who sent an email about something that may have happened in August. As we're not really able to reply to that, don't know what the information was. It could have been a determination. It could have been a one-off. So it's really hard to sort of respond on the fly to those sort of things when we don't have a document from us.
Understood. But you heard me say that if that's happening and it's more than just assuming it did happen the way that it was explained to the court, if it's happening and it's more than a one-off or outside the norm, then that would be of concern, because we've already made clear and you've already expressed to the court that people are not going to be denied merely because their benefit period of time predated when Governor Sisolak declared an emergency.
Thank you, Your Honor. And I guess the last thing that I would say is, I think that when you look at the special master's report, or second report, it's clear that there's multiple issues going on. And the court, I think rightly said, its job is to see whether there is a duty under the law that the Detr is not performing. And the other possible way to issue the writ, I think, is what the court looked at before, was arbitrary and capriciousness. And what we're talking about with those sorts of analyses are really resource allocations. Should Detr be allocating more resources to processing this batch of claims as opposed to this batch of claims, or trying to allocate this issue over another issue? It's an extremely difficult thing for a director to do, or for a special master, or for a court to do. And I understand that the special master did his level best to try to lay out the issues that are in front of this court. And I just think that the resource allocation is a very difficult area for the court to issue a writ of mandate on, because ordering someone to do, or ordering one group to be prioritized, is going to pull resources from another group.
Okay. All right. Understood. And I had a thought I just wanted to make. Again, I want to differentiate what you just said, Mr. Ott, from full compliance with a prior court order. Those are, one's an apple and the other's an orangutan. Okay, they're not the same, and they don't trend together. They're not concurrent. They're different things. But all right, let's talk then about whether this court, first of all, Mr. Thierman, is the plaintiff still asking this court to certify its prior decision under Rule 54B as final? Are you not? Are you asking the court to make an ultimate determination on those portions of the writ of mandate that it had previously denied without prejudice to reconsider as events might warrant? What's your ask right now, and why should the court do it, please?
I ask if these people be paid. The reason I made the 54B motion was because of what the Supreme Court said. And actually, I was kind of surprised that they opposed the 54B motion, because they said in the Supreme Court and in this court that the Supreme Court has jurisdiction. So what cleaner, better way of doing it? Maybe I'm just don't know my Civ Pro well enough, but that seemed to me the penultimate answer for resolving the ambiguity. And that doesn't deprive this court of jurisdiction to make further orders as it sees fit. And I phrased it in terms of a dismissal of my first cause of action, but it doesn't have to be that either. It could, and frankly, it's not usual that a Supreme Court, a state Supreme Court, or the U.S. Supreme Court would actively manage a case. That's a trial court's jurisdiction. And if the court is going to, the answer is it's all keyed up for the Supreme Court. I'm sure they're going to render a decision one way or the other. And if this is an issue of law, if you were a different court, if you were a federal court, you could certify the question. 54B is the cleanest, easiest way to certify the question as I see it. And then we'll know the answer. Maybe there's no duty. Maybe Detr has the right to do whatever it wants to do. And we'll wait for the ballot box in 2 years to see who pays the price.
Okay, let me get the train on the track, though.
Okay.
On a track that I want this train to be on. As this court, reads the Nevada Supreme Court order that came out recently, the court was concerned that this court's prior order left undecided certain issues pending further proceedings. The further proceedings were just like what we just had. Analysis and review and a report from the special master, a little bit of discussion as to what all that meant, and then what this court should possibly do about it. But so are you asking just for 54B certification of finality on the order as it stood?
Yes.
As it now stands, or do you want the court to make a final determination on those matters, the undecided certain issues that the Supreme Court referred to?
If you're gonna modify your order, modify it and then 54B it. If you're not gonna modify it, then 54B that.
Okay.
That is what I'm asking. Now,
All right. Now, if the court were to do that, and of course I'll hear from the state, if the court were to do either of those, then do you believe the court has further jurisdiction to move forward and set this matter for an order to show cause hearing?
yes, both on the contempt, which is an ancillary matter. The second and third causes of action still remain. That's due process, and that was not I mean, the standard is the two ways of saying the same thing: due process and clear duty, but they're different. Okay, and the second cause of action is the 1983 due process action, which leads to an injunction or a mandate as opposed to a writ of mandamus, but it's still the same thing. And yes, you do have that jurisdiction.
All right.
As any court would, you have continuing jurisdiction. Your order said by July 30th you were going to do something, and you didn't. So I assumed at that point it was final. Your last order said that you were going to do something on July 30th, and you know nothing changed. So
nothing changed. Okay, Mr. Ott, your thoughts, please, with respect to the status of this court's prior order of mandate, whether your appeal or the plaintiff's appeal or both together alone has deprived this court of jurisdiction to further rule on its writ, and or do you oppose 54 certification still, and or do you want the court to make a final ruling on those issues that remained unresolved at prior hearings? Which that's one long question, but do your best to answer, please.
Thank you, Your Honor. The short answer is we think that the July 22nd order is final and resolved all the issues, and is a final order that has gone up to the Supreme Court twice now. And so this court is divested of jurisdiction. The two things that were awarded, and there were three things that were reserved, everything else was denied. The order is very clear about that. So really we're talking about the three items that have been reserved for this court's jurisdiction. And our brief lays out why those are so intertwined with the issues that the court has already decided on. None of those three issues were raised in the petitioner's first amended petition, and they're inextricably linked to the issues that have been decided for the reasons that we talked about, the resource allocation issues. I just want to say again that the writs that, in this case, it was our understanding, the writs that did not issue from a clear legal duty. It arose from that arbitrary and capricious standard that the court laid out. And when that is the standard, and we're talking about further orders that may potentially draw resources from other places, those are inextricably linked to the things that are already up on appeal before the Supreme Court. So we think that everything already is before the Supreme Court. It was up before it when plaintiffs filed their notice of appeal. Also, when we filed our notice of appeal. So we think it's before the Supreme Court. And with regard to certification, we don't think it's necessary because we think this is a final order. But to the extent that anything gets certified, the court needs to certify all the issues that it's decided on so that things can go up together and not necessarily just certify out petitioner's issues or just certify out defendant's issues. That, I think, was the point of confusion the court indicated earlier as to why there was maybe a disconnect. There wasn't meant to be one. It was just making sure that everything would be heard before the Supreme Court if anything was certified. And I think the one last thing that I wanted to note is, to the extent that there is a concern about whether this is the most effective way to get these things decided quickly, we did not oppose the expedited briefing schedule or the expedited briefing proposed by petitioners to the Supreme Court. We don't know if the Supreme Court will grant that. An order will issue at some point. But in our view, the most expeditious way to get the issues decided is to have this court render a final order or note that its order already was final, allow it to go up to the Supreme Court, and allow the issues to be briefed before that court.
Okay. And Mr. Rott, you heard Mr. Thierman say he believes that however the court rules on that issue and whatever the Supreme Court does in response, this court retains jurisdiction to hear this second motion seeking an order to show cause why the state should not be held in contempt for failing to abide the court's writ of mandate. You agree the court would still have jurisdiction to hold that hearing?
So that's something that we would like to reserve the right to.
Does the court retain jurisdiction to hold a contempt hearing under these facts, even if the underlying writ itself is up for appellate review?
So that's something that we could certainly address in the briefing if and when it was necessary. But there has not been a stay of the order issued at that point. However, once jurisdiction is decided, whether it sits with this court or the other court, the state may very well file a motion for a stay at that point if we're unable to meet the clear strictures that the court laid out.
All right, the court modifies its prior writ of mandate order as follows. The writ of mandate is denied as to those areas that the court has not previously granted. To the extent the court reserved the right to modify its prior order, I do so now. I modify it by denying the writ as to those other issues. Now, I believe, and that's not going to be for this court to decide, it's going to be for an appellate court to decide, but I believe that by doing this, such order does finally resolve those matters that were sought by the application for the writ of mandamus. The court believes, in light of the cross appeals, the court is now divested of jurisdiction to make any further substantive rulings other than as to those proceedings that are ancillary. So what are ancillary? Well, for our purposes, the court believes it has jurisdiction to hold the hearing on September 10 that the court intends to hold, and then issue an order with respect to the payment of the special master's professional services. The court also believes it has the authority to enforce its prior writ of mandate and to hold a hearing to determine whether the state is not following it. As Mr. Ott correctly observes, there are vehicles available to an aggrieved party to seek to stay enforcement pending appellate review. But until and unless such an order issues, either by this court or a different court, on we go. And so it's the court's inclination to stay the other portions of the case other than having the state respond to plaintiff's second motion for order to show cause why the state should not be held in contempt, and have a hearing on that motion at the same time, September 10. at 9:30 in the morning. What else do I want to say? I think that gives a level of finality at this stage, at least, for parties going forward. It clarifies the court's prior determination. It addresses the concerns that apparently the Nevada Supreme Court had with proceeding at this time. We stay the remainder of our case here to avoid time and expense on the other claims that are not subject to the appeal. And we move forward on the order to show cause until and unless this court believes it doesn't have jurisdiction or it stayed. And we put the state to the task of convincing this court that it is abiding by the court's prior orders. I can tell you both sides preliminarily. I don't have much concern that the state is following the court's order to not deny benefits to someone who did not completely stop working, but rather, had their work substantially impacted, as we've previously discussed. It seems like the state has moved forward in compliance with the court's order, and of course, after receiving confirmation apparently from the Department of Labor that they viewed it the same way, although frankly, the order stands either way, but I'm glad to know that that did not cause concern with the state that it might be following a court order, yet putting benefits in jeopardy for other people in the state. The bigger concern the court has, and would like to spend the bulk of the time on September 10th addressing, is, are people being paid who had payments begin that otherwise are not captured by the court's writ of mandate? They need to be paid. They needed to be paid when I ordered it, and I'd like proof that they have been paid and are being paid. Okay, that will be the court's order this morning. Mr. Thierman, I will give you a chance to make any final comments or inquire of the court if in any way the court's order was unclear.
Your Honor, just one thing. I think as I read the rules on 54B, I came across the section that on attorney's fees have to be filed. And when it seems to be, usually it's when the case is over, but it looks, I'm not sure whether it's if the case is over or whether this topic is over, and I have to make a motion for an extension of time before that time expires. So I would like to move that the attorney's fees motion, if I make one, can come after the final dismissal of the case or final resolution of the case, and not now. I don't know if I'd make a partial attorney's fees motion or have to prorate it or whatever, but I would like to reserve it till it's all over, so I don't have to do it in piecemeal.
Here's what I would say. I'm not prepared to rule from the bench, so to speak, on that. What I would direct is for you to reach out to your counterpart at the state, and of course, seek a stipulation that I could sign off on that preserves your right to make that ask at a later time. That doesn't mean that the state agrees, doesn't mean they agree to the propriety or the amount. It just means that they understand that in the unique procedural posture of this case, that it might be better off to wait and see and not start the clock running if it otherwise would. Mr. Rott, would you like to be heard on that?
I'll look forward to discussing with the opposing counsel when he reaches out.
All right. If you're unable to reach an agreement, then Mr. Thierman, please file a short motion asking for the relief requested. I'll let the state weigh in writing, and then the court will make a decision. Okay. Mr. Rott, anything else you'd like to put on the record, or anything unclear about the court's rulings?
I guess I just want to clarify with regard to The contempt, I know there was a prior OSC or prior motion for OSC filed by.
Well, I would suspect that the more recent updated one is the one that we will proceed under. So the one to respond to in writing should be the second one, but certainly review the first one because argument might occur on September 10th as to both.
Thank you, Your Honor.
You're welcome. The remainder of the case remains stayed. Discovery remains stayed pending further court order.
Discovery of the contempt issue too?
Say it again.
A stay of discovery on the issue of contempt. I mean, how many people got paid? How many people didn't? I don't know. I know how many people I submitted. It's over 200. I suspect that's a small portion, given the numbers we heard today.
Well, I'm not going to telegraph how I would anticipate the hearing to go forward. I can tell you this, though. If I'm defending against a contempt motion, I have people who are under oath going to advise the court as to compliance with the prior court order or documents that are beyond dispute as to their authenticity and to the accuracy of the information contained that can speak to the compliance with the court's order. So if, I'm setting it for a hearing, I'm not prejudging. I'm going to let the state respond in writing to the renewed or second motion for order to show cause. They should do it within 10 days of today. You can file a written reply in response to that. We're going to have a hearing on the 10th. We're also going to talk about the master's bill at that time as well. Unless the order of mandate, enforcement is stayed, then that might change the court's approach. But until and unless that happens, that order is live and controlling, and the court expects compliance. So I'll see everyone again on September 10. To you and your family, stay safe. Mr. Guanasso, at this point, the court asks you to stand down pending further directive from the court. Thanks you again for the excellent services you've provided to the court, to the parties, and to the state at this point, and to the remainder of the people observing these proceedings. Thank you for your interest in the matter as well. With that, the court will be in recess. Thank you very much, everyone.
Thank you.